Often the first person people think to go to for help is a lawyer, which is sometimes the right decision, but not always. There are many different ways that you can negotiate a settlement with your partner. Depending on your situation, making a decision early on about when to engage a lawyer can be the difference between high cost and high conflict, or a more amicable, lower cost settlement. Some of the options you have in front of you include negotiation. You and your ex sit around the kitchen table and work through your custody and relationship property together, called Pro C. The next one is mediation. It is a structured process where an impartial third party, the mediator, assists disputing couples in resolving their conflict through the use of communication and negotiation. The mediator assists the parties to negotiate a settlement. I work with many couples undertaking informal mediations. Collaborative law. It is a legal process enabling couples who have decided to separate or end their marriage work with collaborative professional lawyers, coaches and financial professionals to avoid the uncertain outcome of court. Then there's arbitration. A couple's case will be heard in a private setting rather than a public courtroom before an arbitrator. After the hearing, the arbitrator makes a decision called an award, which is binding on the parties. Now, litigation. This method of dispute resolution is the most expensive and trying on all of those people involved. The parties submit their issues to the family court in order to resolve them. Litigation is used if the ex-partners cannot reach an agreement through other options. Litigation should be viewed as the option of last resort, and only if you believe you are going to have a highly difficult time negotiating what you want. You should try one of the other strategies first to see how much you can negotiate without having to incur the high costs of a lawyer. If you do want to engage a lawyer, you should also think about what you need from them. What have you already decided you want, and what do you want them to help with? You also need to be well prepared for the costs and research which law firms might have terms that suit you. Let's talk now with Caleb Crosland from Chef England about navigating some of these choices. Hi Caleb.
Hi, thank you for having me on.
So what are some of the classic mistakes that people make when it comes to settlement approaches?
Giving a number early and giving a number first. Entering into a settlement when you are emotionally overwrought and doing it without legal advice. And thirdly, doing it without sufficient information and disclosure.
Are there certain relationships that negotiation and mediation is more suited to?
Yes, there is, Bridgette. Most New Zealanders going through separation and divorce are perfectly reasonable people. They don't need to go to litigation. And there is a new method called collaborative law, where each side signs a legally binding document actually saying that they won't go to court. So that forces the professionals to come up with a consensus-based outcome rather than an outcome imposed on them by a court.
If legal arbitration or litigation is required, what sort of costs are involved?
First consultation with most reputable lawyers will be at no charge. You'll probably get 60 to 90 minutes just to get a feel for each other, see if you're the right fit. Beyond that, for a typical dispute, let's say between $750,000 and $5 million, if you come to a litigator to get your court case up and filed in court, I would estimate sort of $7,000 to $10,000 plus GST. To go to a mediation, you're probably spending $5,000 to $10,000 on your lawyer getting prepared, another $5,000 with the mediator. If that fails and you go to litigation, it's a little bit of an open-ended question. It could be into the low 200,000s, but of course when the stakes get higher, even the low millions. It's been my experience where there's more money to fight over, people are prepared to spend more money. But for the average Kiwi, to get yourself going, probably 8 to 10, and then going to a mediation, probably another 15 to 20.
So how would you advise clients on getting the right lawyer for themselves?
Well, a bit like selecting, a knee surgeon or a plumber. Talk to friends and family, find out from people who are happy with the results. So that's the first thing. Make a shortlist. As I mentioned before, most reputable lawyers will allow 60 to 90 minutes at no charge, no obligation to get a feel for one another. Once you're in that situation, my recommendation is find out what the experience of the lawyer is. There's no whiz kids in law. You can't buy experience. Experience counts. So ask your lawyer, how long have you been doing this? How many trials in the High Court or the Family Court, or have you been to the Court of Appeal in that period? And I say that because if mediation fails, you want to make sure that you've got someone by your side in a courtroom who's done it before and has succeeded.
Thanks for joining me today, Caleb.
You're most welcome.
We can help you navigate your choices, and we can help you decide which lawyer might be right for you and how to negotiate with them.